Heledd here from Rothley Law, and I am delighted today to have Carrie Stoneham from Burges Salmon in Bristol. Carrie and I sort of met recently uh, at a family drinks, I think it was, wasn't it? We were sort of celebrating one of your colleagues' retirements, and we just got chatting. Obviously, found out we're both Welsh, which obviously means we're going to be friends immediately.
Of course, that is the law.
But I wanted to talk to you about your role as a family solicitor. And I think family law sits alongside the work of court protection, mental capacity, private client, wealth management, disputed estates. It's all part of the same sort of stable, isn't it? But it is a discipline in its own right. It's got its own rules. It's got red book. We've got,
Yeah.
and the guys have white books, and
Yeah.
there is that discipline, isn't there? So I wanted to talk to you about you and your role in Burgess Salmon, and talking about things like, what your job looks like. So yeah, if you'd like to introduce yourself.
Yeah, of course. Yes. Thanks, Heledd. Yes. So I'm a senior associate in the team at Burgess Salmon. And what I would always say is that no day is ever dull as a family lawyer. Every day is different. And we do a whole variety of different types of work. So we at Burgess Salmon, we specialise in sort of advising high net worth individuals, as well as individuals who may have complex financial arrangements, and especially those who have businesses, farms, trusts, complex pensions, that sort of thing. And we also have a focus on complex financial settlements on divorce. I've also got expertise in acting for clients who lack capacity under the Mental Capacity Act 2005, which I don't need to tell you too much about, Helen, because you're the expert on the Mental Capacity Act. But not all family lawyers sort of come across that scenario a lot. So I do a lot of that sort of work. And we also do a lot of work around asset protection. So prenuptial agreements and postnuptial agreements. And I would say in Bristol and the Southwest, we probably do the highest amount of prenups at Burgess Salmon compared to other firms. So we like to think we are the experts in that area. So that sort of makes up the bulk of our work. We also act for cohabitees as well, seeing a lot more of that sort of work. And there are hopefully reforms on the horizon from the government, but we could do a whole other podcast about that. So we don't want to go into too much detail about that today. So yeah, in a nutshell, that's really what we do in our team. And as I say, yeah, I'm in Bristol. I'm also based in Cardiff as well. So and we have a team in London. So our work covers lots of different geographical regions. So yeah, as I say, every day is different. And I think probably where we do differentiate ourselves quite a bit from other private client lawyers is that we litigate a lot, so we are in court a lot more. Whereas sort of my colleagues in our tax and trusts team would, I don't think they ever go into a courtroom. So that's sort of the key difference, I think, between family lawyers and other areas of private client practice is that element of litigation and having a good old argument sometimes.
No, you're absolutely right, isn't it? Because I sort of with my court protection practice, definitely end up in court, in
Yeah.
person and remote hearings and doing that litigation piece. And the court protection work, I always liken it to sort of family work because, and
Yes.
particularly at children work, you've got people at the centre, you've got to be sensible and pragmatic and best interest and well-being and, primary, who's at the centre of this. And then, as you say, the sort of private client side is that sitting down with clients and going, right, let's structure things for you in a way that is we're working together.
Yes.
Which I think I want to pick up first off on your sort of the prenups and the postnups.
Yes.
Um, that's really interesting because that to me seems like it is an absolute crucial part of any estate planning toolkit. If you've
Yes.
got somebody sitting down and about to, amongst all the sort of wedding dresses and confetti and all the exciting stuff, it can be really important. but it might not be very glamorous, mightn't it? So how do they come
No.
about? How do you even start that conversation?
So what I always say is it's always best to have these conversations as early as possible, and sort of set that expectation from the outset. And there's all different reasons why somebody might want or need a prenup. It could be because they have some family wealth, sort of dynastic wealth they want to protect. So, for example, that they may know that in the future they will come into a substantive inheritance, or they may be the beneficiary of various family trusts. Or it could be somebody that's been married before. They've already been stung before, shall we say? And they may have sort of built up a very successful business or an investment portfolio, and they want to protect that when they're going into a second marriage, or they want to ensure that that wealth is protected for their children from a previous relationship. So that there's all sorts of scenarios as to why somebody might want one. What I would also say is that in a lot of families now, it's becoming more commonplace to have say that it's a requirement for each family member to have a pre or a post step in place. For example, where there's a family business, it's I'm seeing it more and more where children are being told, well, if you want to come on board as a sort of a shareholder and director in the family business, then you need to have a prenup or a postnup in place. And similarly, for them to, benefit from any family trusts, etc. We're seeing that more and more now, where they need to have some asset protection in place. So I think if couples can sort of have those conversations at the beginning, it can make things a lot easier down the line if both parties kind of know where they stand. And it's a lot easier to be able to say, well, this is what my family sort of expect from me. It's a requirement for me to have this in place. It's not particularly romantic to have to talk about them, but I often say, think about it like travel insurance. It's one of those things that you hope you're never going to need. It's always worth getting a decent quality policy just in case, but then you can put it in a drawer and hopefully not need to ever look at it again. But it's important to have it there. So yeah, it's as I would say, I can't emphasize enough really how important it is to sort of have those conversations early on.
Yeah, early conversations, I think it is something that we're all doing.
Yeah.
Because I sit there and go, I can and will do things in an emergency, and we can drop everything, and we can roll our sleeves up and we can get stuck in. But actually, if we can do that planning piece, it's a lot more peaceful, time to think about it. And no matter how good you are, no matter how experienced or whatever, nobody's going to come out of an emergency particularly happy or well, are they? There's always it's going to be a fairly bruising experience one way or
Yes,
another, isn't it? Because it's like,
absolutely.
look, we have to skip a lot of the niceties, we have to skip a lot of this.
Yes.
Whereas actually, if we're doing the planning piece, we're like, okay, let's
Mhm.
iron these things out now. Let's think
Yeah.
about it. Let's go. You've got time to reflect. You've got time to bring it in. And I think the point about, as you say, those dynastic entities, whether that's a trust or a company,
Yeah.
the knock-on impact of a divorce, or not necessarily the divorce piece, but the ancillary relief
Yes.
proceedings, can
Yes.
be devastating. Can
Yes,
be
it can.
absolutely devastating to that business, because it affects other people, doesn't it? And I think it's that ripple effect that perhaps people don't necessarily think about.
Absolutely. And that's another positive about prenups is that it's not just about protecting various assets that you may wish to sort of ring fence, but it's also about, as you say, sort of setting out what would happen if things were to go pear-shaped in the future. And it just means that, if the parties were to get divorced, the financial settlement is mostly already mapped out for them in the prenup. So they haven't got to have this big legal wrangle between solicitors or the court. It's already all of the legwork's been done really. There would still be a few things you'd sort of have to sort out in terms of figures and things, depending on what the actual assets were at the time of the divorce. But ultimately you've done the horrible bits really. So it really saves so much time and anguish when it comes to it, which obviously is the hope that that never happens. But yeah, it's there if needed. So yeah, I can't instill the value of having one enough, really.
And I suppose it gives everybody an opportunity to understand the dynamics of the power play, and if there is an uneven split, you're going into it with your eyes open, aren't you?
Well, exactly. And I mean, there are certain safeguards that we have to follow for an agreement to be upheld. So there was a very famous case, which I'm sure you've come across, Heledd. Anybody who's been to law school will have been. But in 2010, a very famous case, Radmacher and Granatino, where it's a Supreme Court case which effectively said that prenuptial agreements will be upheld here by the courts in England and Wales if certain safeguards are followed. Those safeguards are that both parties need to have independent legal advice. There needs to be full disclosure of what both parties have in terms of their assets and their income. And then it should be no undue pressure or coercion. And that's why ideally we say agreements should be signed 28 days before the wedding if possible. You can get around that if need be. And also the agreement needs to meet both parties' needs. So you couldn't have a prenuptial agreement that left one party with nothing and the other party with all of the assets. That wouldn't be upheld. And the court will always retain ultimate discretion and can ultimately override an agreement if it wished. But generally, as long as the agreement is sensible and largely meets both parties' needs, then the court will uphold that. Or even if it perhaps didn't uphold certain parts of it, it may follow other parts. So it's still generally always worth having as long as it's drafted sensibly. Unfortunately, there is always a bit of an element of crystal ball gazing when you're drafting them because you just don't know what's going to happen sort of 10, 20 years from now. But ultimately we do try and provide for that as much as we can in the agreement. And as I say, if it as long as it meets both parties' needs, then that the courts are following them. So they are definitely not just a worthless piece of paper, as I've heard some people say to me. They are definitely worth that initial investment at the outset.
Okay, because I think prenuptial agreements sound almost slightly American, don't they? And
They
people see them,
do.
like
They do.
see you in
Yeah.
court, and I've got my prenup, and
Yeah.
and actually, it's a hugely sensible thing to do.
Yeah.
And
Yes.
obviously, a prenup is pre-wedding, post-nup, post-wedding. What is the difference apart from obviously the wedding or civil partnerships taking place? How does
Yeah.
that change the dynamic, if at all?
It doesn't particularly. So, of course, with a postnup, it would be very difficult to show undue pressure or coercion because you don't have this sort of looming wedding date that everybody's
Okay.
working towards. So you're already married when you sign that postnup. So there isn't really that argument to say that you were sort of pressured into signing it. I mean, there could be scenarios where you could try to argue that, but it would definitely be a lot more difficult. Where we tend to see postnups more often is where, for example, if somebody later finds out that they are going to be coming into sort of some substantive inheritance or that scenario. But more commonly, it can be where perhaps a marriage has faced some difficulties and the parties have perhaps reconciled and have worked things through. But one party might feel they are maybe a bit vulnerable financially, and they would just like a bit of certainty as to what would happen if there were to be a divorce later on in the future. So that's when, I've been instructed to sort of draft postnups in that scenario is just to sort of say, right, well, we have reconciled now and hopefully we're going to move forward in the marriage, but actually let's just have a think about if we do experience difficulties again in the future, let's have a think now as to how everything would be divided, just to give both parties that certainty and that security. So, but in terms of sort of legal standing, it's the same point in terms of the other safeguards, and that both parties still need that independent advice, and there needs to be disclosure, and the agreement still needs to meet needs to be upheld. So, otherwise they are pretty similar. So again, really worth having in the right circumstances, definitely.
Yeah, and as you say, the options there, isn't it? And
Mm.
that's really useful. I think giving people the opportunity and the option to do this is crucial, whichever sort of side of the planning fence you sit.
Yes.
So okay, completely sensible. What if people go, I wasn't sensible enough to have a prenup, and we got all caught up in the romance, and it was lovely, and we Went off we went and got married, and
Yeah.
then it's a divorce. And I always say to people, I said, there's a difference between getting married and having a wedding.
Yes.
One's a big party, one is a legally binding contract, and
Yes.
it works
Yeah.
both ways. So when we're doing tax planning and estate planning, I go, look, if you don't want to pay for the wedding, just go down the registry office and do it quickly, because it's quite
Yeah.
efficient for tax planning.
Yeah.
But it is a change of state,
Absolutely.
isn't
Yes.
it? It's like,
Yeah.
it's not, you might be living together for 30 years, but actually it is a change of state from unmarried cohabiting to married.
Yes.
And then what happens when that relationship breaks down? You're looking at a divorce, which again, I suppose is in the mirror image, a divorce is different to the financial proceedings.
Yes, exactly. So, yeah, I couldn't agree with you more there, Helen. I don't think people realise marriage is that legally binding contract, effectively, that yeah, you are intertwined financially, in every aspect from then on. So, and I don't think people always appreciate that. But yeah, so the divorce is quite separate from financial remedy proceedings. Previously was called ancillary relief, but now we call financial remedy. So the divorce itself is just a tick box exercise, which you can do online now. And actually, most clients do that themselves. You don't really need a lawyer because we now have a no fault divorce system, finally, which came in 2022. That's just been amazing. It's really taken all the emotional temperature out of divorce because previously we were having to draft petitions on the basis of unreasonable behaviour or adultery, or parties were having to wait sort of 2 or 5 years to be able to petition. And it's really taken all of that stress and anxiety out of it. So it's been a really great reform in the law having the no fault divorce system. So clients can just do that themselves online, which is great. So that's just the process in order to dissolve the marriage. Sorting out the finances is the separate bit, the tricky bit. And ultimately, there's no absolute sort of legal rule or formula as to how the assets are going to be divided. This is just classic family law where nothing is black or white. Everything is just delightfully different shades of grey, I would say. And all of the main principles are set out in the Matrimonial Causes Act 1973. But effectively, the court is aiming to reach a fair outcome. And we always look at what a court would do when we're negotiating a financial settlement. Even if we've got no intention of going anywhere near a court, we always have a mind to what a judge and what a court would be looking at. And they look at a series of factors that are set out in that legislation under Section 25. We call them the Section 25 factors. So they have to look at all the circumstances of the case. And the most important factor is whether there are any minor children. So the court is going to be the most concerned to make sure that those children have somewhere to live and that their main carer has sufficient income to be able to look after them. And then it will look at a load of other factors. So, what are the assets that are available? How old are the parties? What is their health? What are their earning capacities? Um, uh, various. There's a whole long list of factors set out in the statute, as well as sort of the standard of living that was enjoyed during the marriage as well, and how those assets were brought in. Were any of those assets pre-marital, or were they all acquired during the marriage? So these are all different things that the court will look at, and then ultimately how the assets are divided. As I say, will depend on the circumstances. So the main factor is needs. So I feel like this is a word I say multiple times a day. Needs, 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 needs. Needs are paramount. Needs trumps all. So both parties' needs have to be met. Both parties need somewhere to live, and they need sufficient income to live on. And if needs are met, that's when the court will then look at whether there's a surplus of assets over and above
Okay.
what is needed to meet needs. Um, so, for example, if somebody has substantive assets that they acquired before the marriage, um, clients always say to me, I built up my business before the marriage, or I bought this property before we got married, and it's always been held in my name, and can it be ring fenced? And the answer to that is, well, if both of your needs can be met from marital assets, so that's assets that you own jointly or that you've acquired together during the marriage, then there is a possibility that premarital assets could be ring fenced. But equally, if needs can't be met from marital assets, then the court will invade premarital assets in order to meet those needs. So, and that's where a prenup can really come in, because what a prenup can do is to say, well, we're going to really limit those claims as far as possible. So, whilst you can't prevent that, because ultimately, for example, if there were no matrimonial assets or a tiny amount, prenup or not, there is going to have to be some invasion there of premarital assets to be able to meet needs. But a prenup will limit that as far as possible. Whereas I would say the claim could be a lot more open-ended if there wasn't a prenup in place. And what a prenup can also prevent against is what we call a sharing claim. So where there's been a long marriage, there's no definition as to what is a long marriage, but generally I would say you're looking at perhaps 15 years plus. That's where you start getting into sort of long marriage territory. There can be an argument that the other spouse is entitled to a sharing claim to share in all of the assets because they will have been built up over a long period of time during a long marriage. They've both made equal contributions to that marriage, whether that be working or raising the children or whatever that might be. And so there is an entitlement to sort of have a share of what there is. And what you can do in a prenup is to say, no, there will never be an entitlement to sharing, regardless of the length of the marriage. And that would be upheld as long as needs were met. So that's in a nutshell, sort of how it works. And we generally say that in terms of capital, starting point is 50-50. Um, but then, as I say, that might sway more in one party's favour if they need a bit more to be able to meet their needs. For example, if one party can raise a mortgage but the other can't, then that party might need a bit more of the capital because they're not going to be able to get a mortgage to sort of buy a house. That's just one example. So that's sort of generally what we say, but there's no sort of hard and fast rule on these things as ever. It's very sort of bespoke to the circumstances of each case as to what the outcome might be.
And met needs is something I often spend a lot of time talking about when I'm talking about care fee planning.
Of course, yeah.
Because it's really interesting that actually it's the same language because it's met care needs are not the same as desired care needs,
No, no.
and I imagine it's that's very similar sort of scenario where you
Yeah.
find people going, well, I want to live this lifestyle, but that's unreasonable
Yes,
when you can
absolutely.
be met down here.
Yes, and I have had this on on quite a lot of cases of older the older generation sort of getting divorced. It does happen, and I've had a few where one spouse is in a care home, and we have to sort of factor that in when we're looking at a financial settlement. So we've had to get expert reports as to care needs. So what are their current care needs? What are their care needs going to be in the future? For example, if someone's got sort of mild dementia at the moment, that dementia is going to progress. They're going to need more intense dementia care. As you will know more than me, Helen, that's going to be extremely expensive. So we need to look at and also what's their life expectancy as well. That's also got to be factored in. So it's kind of looking at all of that and thinking, well, here's the pot, and it may be that person in the care home is going to need a larger proportion of the capital because they have care needs that the other party simply doesn't. So it's sort of factoring all of that in really, so that and we would always get expert evidence for that. It's not really for us to have a guess at what care costs might be, but equally the cost of care is just escalating every year, isn't it? It's just
It really is, and it's really interesting because we sort of like this sort of silver splitter notion.
yes, yes.
As you say, the older generation splitting up for all sorts of reasons, and it just reminds me that I have had on more than one occasion, husband and wife.
Mhm,
One's gone into care.
mhm.
there's an uneven distribution of assets because that's how they've historically done it.
Yeah.
We are where we are,
Yeah.
in that respect.
Yeah.
And the wife, usually who's not in the care home, doesn't have as much money.
Hmm.
And we've been having conversations with local with sort of financial assessments and what have you as to how much money should be taken into account for care.
Hmm.
And on more than one occasion, I've had to sit there and go, if we're not going to get a sensible response, I'm going to suggest my client starts divorce proceedings,
Yes. Yeah.
which
Yeah.
is a really hard thing to have to say to somebody. He goes, but the only reason that I'm not with
Yeah.
my spouse is because they're ill. And I go, yes, but there is a knock-on financial impact. And if we have to go down the divorce route, you're going to get what you're entitled to.
Yes. Yes.
And it's really interesting to hear you say that you're doing those expert evidence, you're doing that life expectancy. As you
Yeah.
say, cost of care is going through the roof. I mean, I
Yeah.
think it's £2,000 a week in Bristol is not unheard of.
It's just crazy, isn't it?
It really is, and we're seeing in the news, aging population and all that.
Yeah.
So
Yeah.
it's almost sort of like, actually we need to be thinking as lawyers, this
Hmm.
is potentially a looming problem,
Hmm.
and maybe back to that pre and post nup
Yeah.
aspect
Yeah.
actually could be
Yeah.
really useful.
Yes.
Um,
Yeah.
Setting out that, again, if we've got sort of second marriages, or cohabiting because one partner's died after a long marriage,
Hmm.
cohabitation agreements,
Yeah.
these things are
Yeah.
probably all things we should probably be talking about much more
Yeah.
openly,
Yes.
from a,
Yeah.
actually this is not a very straightforward linear scenario.
No. No.
The conjoining of
Absolutely.
finances, yeah.
Yeah, absolutely. And as you say, even with cohabitees, if you have sort of, again, it tends to be sort of older generation, maybe thinking about a second marriage, and then they think, oh no, actually, we'll avoid marriage because of that knock-on effect in terms of finances, and they may sort of be concerned about inheritance for their children. But again, I think what's often overlooked is the possibility that if you are cohabiting with somebody for a period of time, and that one party was to die, then there's a potential Inheritance Act claim there. So it's then looking at, perhaps if you are going to cohabit with somebody, or especially if you're going to own a property with them, it's looking at, right, declaration of trust. Let's look at a cohabitation agreement, sort of setting out the financial arrangements here, and having a really good will in place to try and safeguard against sort of future disputes on that person's death over, a potential Inheritance Act claim, and disputes with sort of children and etc. So it's thinking about all of that as well. It's not just marriage. It's a lot of future proofing on any sort of arrangement.
Yeah.
Um, I
Yeah,
think.
it's utterly fascinating. Now, I wanted to come back to something you said at the beginning about litigation, because
Yes.
ultimately, if you can't, if this isn't possible to negotiate and settle and what have you,
Mm.
it's litigation.
Hmm.
And sometimes that's what it takes, because you
Hmm.
might have a party who is being unreasonable on the other side. And what does that look like? What does litigating your
Hmm.
divorce look
Hmm.
like for
Yeah.
somebody who might have no idea what's involved? I mean, we're all like, oh, it's fine, it's cool, it's not a problem. Actually,
Yeah, we do,
for
we
the
do it
first time,
every day.
yes, if it's the first and only time you're going to do it, it's quite intimidating. So,
Yes, it is. And this is what I always say to clients is that court proceedings are not nice. It's never nice to be in that scenario at all. So that's why we really try and avoid it at all costs. And our approach, especially at Burgess Salmon, is that we are fully prepared to litigate if we need to, as you say. And sometimes that is just necessary because if one party won't engage, or they just won't provide disclosure, or there are just fundamental differences as to points of law on how a settlement should be formed, then ultimately you have no choice but to issue proceedings. But otherwise, our approach is very much, let's try and get this done constructively, and amicably as we can. If you do have to go down the court route, it's structured, that the court process is structured to try and encourage the parties to settle at any point. And the courts are really taking quite a strict view now on making sure the parties have really explored non-court dispute resolution. And there's a really big emphasis on that now. So the court wants a very good reason as to if the parties have not gone to mediation, for example, why have they not gone to mediation? The courts are really not liking, issuing for issuing's sake. There really should be a good reason why. So again, mediation is something we really encourage for parties to try and reach a settlement. It's cheaper, um, it's less, the word, it's less confrontational than using lawyers. Both parties are sat with a lawyer trained mediator, but it can just be a much more amicable way to reach a settlement. It's not for everybody. If there's been domestic violence, or ultimately, you may try a few sessions and you're just at an impasse, in which case fine. But the court really does expect you to have a good go at that. So as I say, there's a big emphasis on that. If you still have to go ahead with court, as I say, it's structured to try and still encourage that settlement. The first hearing is just a housekeeping hearing, so that's where the court will just make directions as to how the case needs to be managed going forward. So is there any outstanding disclosure issues? Do we need to obtain any valuation evidence? It'll sort of make directions on all of those sorts of points. So the parties will have to attend court. They won't actually have to say anything, but they still have to sit in a courtroom, and that's pretty scary, I think, if someone's never been to court before, going through the metal detectors when you first go there, like you're in an airport security. It's not nice. The next hearing is what we call a financial dispute resolution hearing, and it's sort of like a court-led mediation a little bit. So the court expects both parties to put forward what their positions are, and the hope is that by FDR stage you will have all the disclosure that you need and all the valuations that you need. And it's very much about trying to negotiate a settlement at that point. So both parties will put across their views, and then the judge will give an indication as to how they think the case should be settled. It's not a binding indication, but it can really help focus the parties. The judge will sort of highlight weaknesses and strengths in the respective parties' cases, and sort of give an idea as to what they think the outcome should be. And the majority of cases sort of settle at that hearing or shortly afterwards, because it really can help the parties focus. What I would say is that, and this is not unique to family law, but the court systems are overrun. There's far too many cases as opposed to the number of judges. And very often you'll turn up for an FDR hearing and you may have a judge who has 6 other cases in the list that morning, and they don't have the time to read all the papers and give you that time that the parties need to give a good indication. So it can cost the parties quite a lot of money to go to that hearing, and ultimately they may not get particularly good value for money out of that. So what we are now doing a lot are what we call private FDR hearings, which are outside of the court process, where both parties jointly pay for a retired judge, or don't have to necessarily be a retired judge. Some barristers do it as well, but they effectively pay for an FDR judge. And we have sort of an FDR hearing. So we hold them at our offices, or we'll do them at barristers' chambers. And you'll have the judge for the whole day. They'll read all the papers. You can go back and forth multiple times to see the judge, to give an indication on various points. And can be just such a great way of reaching a settlement. So we do those a lot, and they're not appropriate in all cases. And it can be, they can be expensive, but ultimately I think in the right cases worth the money, because as I say, you're generally going to get a lot better value from that than using the court system. Ultimately, if you still can't reach a settlement, then that's when the case goes to a final hearing. That's when both parties have to give evidence. So that's the really horrible, horrible bit, where they'll both be cross-examined by barristers, and then a judge will make a final order as to how the assets should be divided. And who wants that? Who wants a judge deciding how your assets get divided? Nobody wants that. Everybody should want to retain control over their lives, and their money. So it really is a last resort. And to even get to a final hearing, you're sort of looking at at least 12 to 18 months from when you first issued proceedings, if not longer. And the costs can be astronomical depending on the issues in the case. So it's really something to be avoided. And in practice, final hearings are really quite rare. I would say less than 1% of, yeah, sort of 1 or 2% of cases get to a final hearing. So that is really, really rare. There are all sorts of other options we can use as well to try and reach a settlement. So whilst the court process is going on, we'll be exchanging correspondence, we'll be exchanging without prejudice proposals, open proposals. You know, the lawyers will be trying to reach a settlement without having to use the court process, and that will happen throughout. And there are other, there are other things to consider. Arbitration is proving more popular. Early neutral value evaluation, and as I say, I keep harping on about mediation, but I can't instill its virtues enough, really. And again, you can have shuttle mediation if parties are sort of concerned about that power dynamic. If one party might perhaps be a bit difficult, you can have shuttle mediation where you don't have to sit in the room together, or even solicitor supported mediation where you actually have your lawyer with you at mediation can also be helpful. So, all roundtable meetings. There's all sorts of things we can try and do
And
to reach a settlement without.
what I'm really hearing is actually collaboration, try to sort
Yes.
things out sensibly without that sort of see you in court mentality. And I know we've talked about this. Actually, Bristol's legal community is really pretty good at
Oh, yeah.
being collaborative, because we both have a hatred of 5 p.m. on Friday emails.
Yes, there's nothing I dislike more than a 5 o'clock email on a Friday. Yeah, I mean, at Burges Salmon, we're all members of Resolution, and a lot of family lawyers in Bristol are members of Resolution, which is a nationwide organisation for family lawyers, which really promotes a constructive approach to trying to resolve conflicts. And I think the ideal is for both parties to come through a divorce with some sense of some sense of a relationship still there, especially if you've got children. You still want to come out of that where you're able to communicate with each other if you can, and just sort of coming out of it with your dignity still intact ultimately, where you can feel like you had, in inverted commas, a good divorce as far as there can be one. Resolution has a code of practice that we all try and subscribe to, which is, for example, we don't mix in correspondence, we don't mix children and money issues in the same letter. So if there's issues about the time the parties are spending with the children, I would send that in a separate letter to a letter about the finances, because the two should not be interlinked in any way. We don't condone sending emails after 5 o'clock on a Friday or on a weekend. It's little things like that where it's just to try and avoid conflict wherever possible. And I sit on the practice standards panel for Resolution, and it's where we look at sort of complaints that members of the public or other legal professionals can make to Resolution if they think that a member is not upholding that code of practice or that code of conduct. And it's been really interesting actually to see. Practices in other regions who, not so much Bristol, but who are really sometimes really don't follow those sort of values and can really be very aggressive and confrontational in correspondence. And it's just not necessary. There's just no need for it. It's not the lawyers who are having the arguments here. And
No.
actually, I think it's our job to try and take that heat out of it and just try and get things resolved as quickly and as amicably as possible. So yeah, again, that's really our focus really is that non-confrontational approach. Definitely. And Bristol is, as you say, is great for that. We've got a really active resolution committee in Bristol. We do a lot of events and training for members. And the Bristol legal community really engage with that, which is great. Whereas I know in other regions, it's a bit of a slower uptake, but I'm hoping now as the younger generations are coming through, that's getting promoted more and more. And we'll start to see less of the old ways of, yeah, sort of 5 o'clock emails.
Yeah, please don't ruin anybody's weekend. There's no need.
There really isn't. There really isn't. Because what can you expect to gain from that? A
Yeah.
party's just a party's not going to be able to take legal advice on a Friday night generally or over the weekend. And so all they'll do is think about that all weekend and just get in an absolute state about it. And it's just not going to help anybody. Yeah, there's really no need for it. And if a client ever asks me to do that, that I will always say that's just not my approach. I'm not going to send things late on a Friday. It's much better to hold it. And as I think we were talking about earlier, Heledd, you can do a delayed send
Yeah,
to send first thing on the Monday morning instead. And that's always going to be more preferable, definitely.
absolutely. Well, Carrie's been absolutely brilliant. I mean, I've learned more about family law and divorce than I'm sure I did when I was doing it when I was doing it in university. So
Oh gosh.
it's been absolutely brilliant. Thank you so much. And I really like the collaboration, talking piece. And I think on that note, I think, that's what I want to say. If anybody wants to talk to us and get to a solution, that's what we're here for, isn't it?
Absolutely, we definitely are. But thanks, Heledd. It's been a pleasure. Thank you for having me.
Thank you.